Good morning. I'm Aaron Hall. We're coming live here at 10 a.m. on May 3rd from the Minneapolis, Twin Cities, Minnesota area. Let me give you a quick intro about what we're going to do today. We are going to answer a number of questions that have come in, but first priority goes to anybody who has a question and puts it in the comments section below. So live questions will be answered first. Other questions we will answer second. A little about me. I'm an attorney. I work with business owners and entrepreneurial companies. I created this YouTube channel to help business owners avoid some of the common problems that are experienced in new companies. These problems I've seen time and time again, and it's so frustrating for the business owners going through those experiences. And they're saying, why didn't anyone ever tell me about these problems? Or how can I learn about other problems to avoid? And so over the years, as I've been practicing law, I made a list of all these areas with business owners where I saw problems that could have been avoided with a little more education, a little more understanding of how the law works, and a little bit how business works. So this YouTube channel was created with the idea of empowering business owners with general educational information. Now, that leads me to the first point. This is public. This is public information. So if you're going to put any sort of comments on here, please make sure you don't mind them being broadcast to the public. This is live on YouTube and it will stay on YouTube. So if you don't want something shared, if it's confidential, please don't post it out here. Second, this is educational information, which means I'm not an attorney representing you. Why is that important? Because the process of representing an individual is a conflict check, asking questions about the details of their situation, and then giving them specific advice for that situation. Contrast that with what we're doing today. This is general education, which means it's a great time to ask general questions. But if you are looking for advice specific to your situation, you're able to answer or ask general questions here. But I would encourage you to use my answers to inform the discussion that you have with your attorney. In other words, this is general education. Please use the information I give you to identify issues to discuss with an attorney who can take the time to understand your circumstances and your goals and your concerns, and who knows the law in your jurisdiction. I don't. I only know the law in Minnesota. All right, so this is public. Everything on here remains on YouTube. Please don't share anything that's confidential. If you have questions, you're welcome to add them in the description below. You might be wondering, is there a place you can go to get information about common problems experienced by business owners? And the answer is yes. I put together a free download available to you. You can get it at aaronhall.com/free. It includes the 7 most common legal mistakes made by new business owners and how to avoid them. You'll get both the download and you'll then receive free educational videos from me sent by email. And each one of those videos will explain those problems and how to avoid them in your company. These videos are not available on YouTube or anywhere to the public. They are exclusively for people who have subscribed to the channel. All right, let's get into the questions. The first question for today is, I have an LLC and want to do a DBA. I have insurance for work that would be done under the DBA. The insurance is in my name, not the DBA. Is that a problem? I am and will be the only employee under the DBA. All right, so great question. This is the type of question that may require subsequent follow-up questions from an attorney to advise you on what is specific to your circumstances. But I'm going to use that question as a prompt to cover some of the big issues that are here so that people can address some of the common misunderstandings with DBAs. All right, so let's imagine you have an LLC. So that is a registered limited liability company in your state. You want to now add a DBA. Okay, well, the question is, what is a DBA? DBA stands for doing business as. And I think that language is really helpful because it's not a separate entity. It's just, for example, an LLC doing business as, and then a new name. So, for example, you might have Goldilocks Cookies LLC. But then Goldilocks starts making brownies. So Goldilocks might set up a DBA called Goldilocks Brownies. Legally, it is Goldilocks Cookies LLC doing business as Goldilocks Brownies. Is Goldilocks Brownies a separate business entity? No. It's simply another name for Goldilocks Cookies LLC. So some states sometimes call it an assumed name. You might think of it as an alias or a nickname. So, for example, if Robert also is known as Bob, it doesn't mean we have two people. Bob and Robert aren't two people. It's just a nickname. Bob is a nickname for Robert. So when you think about a DBA, think about nicknames. That will help avoid some of the common confusion people have about whether a DBA is a separate business entity. Okay, let's go back to the question. I have insurance for work that would be done under the DBA. Well, as we just discussed, insurance or a DBA is not a separate entity. It's just a new name for the existing entity. So if you have insurance that would be done under a DBA, what you really mean is the insurance would be done under the LLC. And that's great. That's exactly how insurance should be set up. Back to the question. The insurance is in my name and not the DBA. Okay, well, let's think about that. The insurance can either be in the LLC or your name. And it matters because if a lawsuit is against the LLC and you were sued personally, the question then is, okay, are you covered? And the reverse is also true. If you have insurance under the LLC and they sue you personally, or vice versa, they sue the LLC and not you personally, you get the idea that you need the policy under the proper person or entity. So what do we do? Do we have it under the LLC or the individual? Well, a lot of times insurance companies will let you do both. So that is certainly an option. You just need to make sure both are what's called named insured. So you want to make sure that if the LLC owns the policy, you individually are a named insured. So going back to the question, is it a problem to have an LLC with a DBA and insurance? And I think the question there is, how do we avoid being liable or having liability if we got this insurance policy that's supposed to cover us? So here's how you do it. You have an LLC for your business. You can have a DBA for that. That just means a nickname. But the insurance policy can be in the name of the LLC, and you individually are the named insured. Or you can have the insurance policy be in your name, and the LLC is a named insured. Okay, that covers it for that question. And I am checking in the description box to see if there are any follow-up questions. Since I haven't seen any, I will move on to the next question. How do you name a holding company? Well, first, what is a holding company? A holding company is a business, an LLC or a corporation, that holds assets, but it does not engage in operations or business activities that could result in it being sued. So let's imagine, for example, you have a health club, a fitness facility, or a gym, and that gym has a bunch of members. But in order to fill the gym with equipment, you had to buy the equipment. Now, what some people will do is they won't have a holding company. They'll just have one LLC. That will be the business. You fill the gym with all the equipment. But then if there's a lawsuit, you have a threat of losing all that equipment if you are found liable for the lawsuit. So I'll give you an example. Let's say one piece of equipment breaks down, and it breaks down on a really busy day. And one of the members or customers comes up to the front desk and reports to one of your staff members that that piece of equipment is broken. They might even say, hey, it's kind of dangerous. Nobody should be using it right now. Well, let's say that staff member doesn't immediately walk over to that piece of equipment and put a sign on it saying, do not use. For whatever reason, that staff member gets distracted, doesn't get to it, and a couple hours later, somebody goes and uses that equipment and gets seriously injured. They then sue, or actually, what happens is they typically go get medical treatment, submit those medical claims to their insurance company, and then their insurance company sues your business to reimburse for the medical expenses that they had to cover. So keep in mind, it's often not even the member or the customer that's suing. It's their health insurance company that wants reimbursement for all the medical expenses. Because you might think, oh, my customers would never sue me. Well, a lot of times they don't have a choice. It's the insurance company that does that. Of course, the person could just pay out of pocket all their medical expenses, but for most people, that's not an option. They can't afford it. That's why they have health insurance. All right, so the health insurance company sues your gym. Now what? Well, if you have an insurance policy for that sort of injury, that insurance company would kick in. But let's assume, for the sake of this scenario, that you don't. We have this lawsuit come in, and now you have to hire an attorney. So that's expensive. You're going to pay out of pocket for that because you don't have an insurance policy. And unfortunately, in the scenario I set up here, you're probably going to lose. Why? Because your staff was told there was equipment that was defective and dangerous, and they didn't act reasonably. They didn't go put a sign on it telling people to don't use that equipment. They delayed and somebody got hurt. So that scenario lays out fairly typical negligence. Court, let's assume the court then rules that you were negligent or your business was. A judgment is now issued by the court. It's a piece of paper that says the company is negligent. The company owes money. What happens next? Well, the creditor, that's the person who won the lawsuit, the customer, can now ask the sheriff to have a sale of all of the company assets. So there is a legal process where the sheriff can go in and essentially freeze the assets and conduct an auction. The sheriff typically gets a percentage of the proceeds from the auction. The remainder of the money goes to the creditor. The auction's publicly advertised, etc. So as you can see in this big scenario, you had a lot of equipment that can now be lost to a creditor. So if it was a small business or $1,000 of equipment, you probably don't care. But if it's $100,000 of equipment or more, it may make sense to have a separate company hold that equipment. So if there's a lawsuit against your gym, that separate company can't lose all of the equipment. That separate company is called a holding company. The idea is that it holds assets like gym equipment or real estate or other stuff. And ideally, it holds stuff that you're not going to get, or it's not going to get sued over. All right, so we're talking about just where are we at so far? We're talking about holding companies. What are they? They're a separate business entity, like an LLC or a corporation, from the business that might get sued. So, on the hypothetical here, a gym. Now, how do you name your holding company? What sort of name should you do? So, for example, if your gym is called Strength Fitness, do you call it the holding company Strength Fitness Holding Company? No. And I'll explain why. Imagine there is an attorney who is preparing a lawsuit for the health insurance company to sue you or your business for defective equipment. They're going to check in the Secretary of State's listing or whatever state you're in for the listing of businesses, and they might type in Strength Fitness. Well, two hits would come up: Strength Fitness LLC and Strength Fitness Holding Company LLC. And that attorney is going to go, we maybe should sue both of them, and then let them in discovery. We'll figure out who's actually liable and who has assets, etc. So you don't want to pick a holding company name that's very similar to your business name. Now, another related question that business owners often ask is, well, should I pick something like in my own name or maybe like related to my name or my kids' names? So, for example, if the business owner's name is Susie Smith, should it be Susie Smith Holdings LLC? No, I don't recommend that either, because if a creative attorney is about to do a lawsuit and they type your name into the business search records, they're probably going to find your holding company. So, in fact, sometimes a holding company name comes up in discovery. It is a best practice to have the holding company name something totally unrelated to you that nobody would think of for you. Now, sometimes I've heard people say, well, what about it like a favorite sports team or the street I grew up on or something like that? I don't recommend any of those because they can be tied back to you. And I've seen where business owners try to get cute with the name, and then unfortunately, somebody finds that holding company and decides to bring legal action against it. Now, you might be able to win, but imagine now having to hire a whole separate attorney in many cases to defend that holding company. So if you're naming a holding company, pick a name that has nothing to do with you. It might be, I've seen 123 Birch LLC, or geographic terms can work well, like Everest Holdings LLC, or Topeka Holdings LLC. In fact, you may not even want to put the word holdings in it. I'd recommend that you don't, because when you put the word holdings, it's kind of like putting a target on there saying, hey, this entity has assets. If you can find a creative basis to sue it, go after it. So many times you won't even put holdings on it. You'll know it's a holding company because it's where you put all your assets, but you're going to just give it a very generic name. So to kind of recap here, the holding company's name should not have the name of your business or anything similar to it. It should not have your name or any nickname or fun little thing that could be connected to you. And it should not have holding company or holdings in it. You want a name that it doesn't attract attention. So that answers the question of how to name a holding company. Let's move on to the next question. How do you protect confidential information in your business? Well, perhaps the first question is, why would you even want to? Confidential information is really important for trade secret law. Trade secret law basically says the people that are in your business, your employees and your contractors, cannot share the information you have with your competitors or anyone else. You might say, oh, I've got great employees. They would never do that. Well, often it's not the employees who work there now, it's the people who leave, or more importantly, were fired. And they're disgruntled. They're mad about being fired. And they decide, oh, I'm going to use some of the information I had previously and go to a competitor of yours and see if I can use that at you and to make money in the meantime. The Trade Secrets Act, which is both federal law and in many states like Minnesota. So, and to be clear, federal law applies to the entire United States, but then every state or many states have their own trade secret law. This law says nobody can use confidential information within the business except for the purposes of the business, obviously. So, if you don't keep information confidential, or if you don't make reasonable measures to keep it confidential, it's not in this category of protected confidential information. It's not technically a trade secret, which means your employees can share it later. So I had a real scenario where there was an effort to get access, or there was a trade secret case, and an employee took a bunch of information from his former company to a new company. And there was now a question of whether that information he took was trade secrets. The employer sued this former employee and said, you took all of our confidential information and our trade secrets. And the attorney for the employee who was in our firm, the attorney said, you know what? All we have to do is prove that these weren't trade secrets. How do we do that? We show that the secrets, or that the information that was shared was not actually kept a secret. It was not kept confidential. How do we do that? We look to see whether their IT vendor, the company they use to work with their computers, had access to the information, and whether the IT vendor had signed a non-compete or a confidentiality agreement. And here's why that's so important. And this is brilliant. If the IT vendor did not sign a confidentiality agreement and had access to the same information that this ex-employee took, then the employer did not reasonably keep confidential the information. It was shared with a vendor who had no restriction on sharing it other places. So by establishing that the IT vendor had no limits to the access of information and had no restriction on how they use that information, we were able to argue that the information was not reasonably confidential, which means it was not a trade secret, which means the employee could do whatever he wants with it. So, why is it important to protect your confidential information? So that your competitors can't get it. And one way your competitors can get it is ex-employees. There are other ways as well. But so how do you protect your confidential information? Make sure it's marked confidential. That's a great way. So that's step number one. Step number two, make sure any contracts that give access to your data have a confidentiality provision. So for example, if your IT provider has access to your computers, make sure that they agree in the contract to keep all of that information confidential. And then take other reasonable measures to keep that information confidential. What are examples? Well, you might have an occasional announcement that everybody needs to keep things confidential. It probably says in your employee handbook that you need to keep information confidential. Maybe there's an agreement that employees sign before accessing computer equipment. Generally see this at larger companies. The employee has to agree that all the data on there is owned by the company and it's confidential unless they are authorized to share it to perpetuate the goals of the business, but they are not permitted to use it for personal purposes or other purposes than perpetuating the goals of the business. So that is why protecting confidential information in your business is important. What is that confidential information? And protect confidential information. Questions from the audience? All right, I'm going to tackle the next question. What is disgorgement? Disgorgement is where a big claw or hand comes in essentially and grabs something and pulls it to a new person or entity. So I just visualize this big claw reaching in and grabbing money and anything else that is authorized as part of a disgorgement. So here's the scenario where it comes up. Let's say you have a business owner who owns a business with her partner. Both of these two business owners are working together on the business. Things are going great. But then one of the owners says, you know what? I'm going to start a side business that competes with the business we own together. And for one of these big potential customers I've been talking to, instead of having that customer go into our shared business where I'd only get half the profits, I'm going to have that big customer go into my other business, that business that's competing with our shared business. Because that way, she'll get all of the profits from that big customer. Well, you can't do that. That's a breach of the fiduciary duty of loyalty. All business owners owe a duty of loyalty, a duty not to compete with each other and with their business. So if the business partner who was innocent decides to sue, a court could rule not only does the bad business owner owe the money, but any profits that were generated in that other business owned by only the bad business owner will be disgorged and brought to the partnership. So that's an example of disgorgement in real life. It's when a court orders that another company, and a company that might not even be a party to the case in rare circumstances, must disgorge those profits and bring them back because they were illegally in that other entity or wrongfully in that other entity. So what is disgorgement? It's simply when a court or some other authority grabs assets, often money, funds, and moves it to another entity. Another example of disgorgement is when a bankruptcy trustee finds money that was improperly transferred from a person who filed for bankruptcy to another person or entity. The bankruptcy trustee can reach out and disgorge those funds and bring it back into the bankruptcy estate to be used for the creditors of the estate. All right, let's take a look at what is the next question here. What is licensing? And what are ways to make money from a license? A license is basically permission. So if you're thinking about how do I think about licensing, just think about permission. So for example, if somebody owns a song and the copyright to a song, and you get permission to use that song, you have a license. Likewise, if you get a license, you've gotten permission. So license can seem confusing because we have driver's license and hunting license and all these things. But the word permission helps make it a lot clearer. By the way, for a driver's license, it means you have permission to drive. For a hunting license, it means you have permission to hunt. And of course, every license has limits or a scope. So, for example, if you have a hunting license, it doesn't mean you can hunt any animal you want. It doesn't mean you can shoot anywhere you want. There are still restrictions on that hunting license. Likewise, when you have a license to use a song, there are restrictions on it. So, a license is simply permission to use somebody else's intellectual property. That intellectual property might be a trademark, a copyright, a patent. It could even be something else. But ultimately, a license is just permission to use somebody else's intellectual property in the specific way that is authorized by the intellectual property owner. All right, how can you limit a license? You can get extremely creative because it's just a contract. So, can a license be done orally? Yes, you can give permission orally. Like, let's say, for example, you know the owner of a song, and you say, "Hey, can I have that song play at my wedding? Is that okay with you? And can we do it for no charge?" And the owner says, "Oh yeah, sure, that's no problem." Boom, we have a license. We have an oral license. There might be restrictions on it though. And those restrictions in this scenario are you can do it at the wedding. It doesn't mean you can now re-release it and start selling it on Spotify and YouTube and as CDs. And you might say, well, how does that work if it's oral? Like a lot of times you don't sit and discuss every little detail. Like for example, if I said, "Hey, can I play your song at my wedding?" Um, what are all the details there? Well, we don't always have all the details, but a court will imply reasonable details. So, in other words, if somebody says at my wedding, a reasonable person would probably assume that's a specific event. If you get married 5 times, it doesn't mean you get authorization at all 5 of them. Why? Because a reasonable person would probably assume it's for a specific event. And by the way, if that wedding is broadcast live and then recorded, and you go on and sell the recordings, and let's say you want to sell the little clip of the music, can you do all of that? You might argue, well, hey, I got permission to do it at the wedding, and they didn't ask whether it's live, and they didn't ask whether I'd be selling recordings of clips later. But the court will imply reasonableness. And you might say, well, okay, how do you figure out what's reasonable? It's in the mind of the judge or the jury. So you're going to have some third party or parties, judge and jury, deciding what would a reasonable person think. So it's not whether you can argue the technicalities. If details are not either specifically discussed or expressly put in a written contract, the court will imply reasonable terms on that license. All right, do you have any follow-up questions? So far, I don't see any. Let's move on to the second part. What are ways to make money from a license? A license is a contract which can include some sort of compensation. It might be a fixed fee, like you can use my song at your wedding for $300. Or it might be a percentage. You can sell my song as a CD and I get 80% of the proceeds or 20% of the proceeds, whatever it ends up being. Or it could be some sort of complex formula, like after you deduct certain expenses from the proceeds of selling my CD. I get 50% of the proceeds and you get, or the profits, and you get 50% of the profits. It can vary over time. For example, a license might say in year one, we split the proceeds in these percentages, but in year two, we change the percentages. And in year three, we change the percentages. Or it might say after 2 years, the license ends and you no longer have authorization. What are other creative ways to set up a license? Well, really, sky's the limit here. Anything you can think up is possible to write in a contract. So whether it's a fixed fee, a percentage, some sort of complex formula or calculation, uh, it can even be a contingency. For example, if the movie makes over $10 million, then the percentage of the movie's proceeds, say 2%, will go to the writer of the movie, for example. So you can build in contingencies or if-then statements as well. All right. We're going to do one more question today, unless I get something quick in the comments. And this next question is, what's the difference between a non-compete agreement and non-solicitation agreement? Well, a non-solicitation agreement usually says that a company's employees and vendors cannot be solicited by the person signing the agreement. So, for example, let's say a company asks an employee to sign a non-solicitation agreement. It will basically mean if the employee leaves the business for 2 years, they will not solicit any employees of the company or any vendors or customers of the company. In other words, the employee can go his or her separate way, but the employee should not leave and then try to hire people away or try to recruit or sell to some of the relationships that the employee had as part of being with the company. That's a non-solicitation agreement. What is a non-compete agreement? A non-compete agreement is where a person agrees not to compete in the same line of business for a period of time in a certain geographic area. So, for example, let's say a hairstylist signs a non-compete agreement and it says, I will not offer hair cutting and styling services within a 5-mile radius of my former salon location for 2 years. That would be a fairly typical non-compete agreement, which means in that scenario, as long as the stylist moves outside the 5-mile radius, the stylist can compete. And the stylist could contact her old customers and say, hey, I have a new location. It's 6 miles from my old location. Would you like to come get your hair cut here instead? And the stylist could reach out to her other stylist friends at the old employer and say, hey, do you want to come join me here? You can make more money and we'll do this together and it'll be fun. Because the stylist in this scenario only signed a non-compete agreement for 5 miles. But if the stylist signed a non-solicitation agreement that prevented soliciting employees and customers, then it would be improper for the stylist to solicit those folks or even to serve them or provide services if they solicit her. That's usually how that's written up. I have other resources on this topic, which we'll put in the description below, so that if you want follow-up information on some of the topics we've talked about today, there will be a number of videos available for you to click on and go a little bit deeper than what we've done today. All right. Well, this wraps up this live session. Where if you have found this helpful, love to get your feedback. We may do more of these if we find that they are helpful to people. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. You can find more about me at aaronhall.com. You can get the free download we talked about earlier at aaronhall.com/free. And if you have questions to follow up from today, feel free to put them in the comments section below. I'll either address them in a future live video session, or I'll use your questions to create an entirely separate video to help you and other business owners, educating you to help make your company better and hopefully improve your success in life. It was a pleasure talking with you here today.